stop scrolling right now. If you're married, engaged, or even thinking about divorce, the next few minutes could literally save you thousands of dollars and years of courtroom battles. Marriage and divorce laws in America have undergone massive transformations recently, and most couples are completely blindsided when they find out.
I'm talking about game-changing updates to prenuptial agreements, revolutionary approaches to dividing assets you didn't even know counted as marital property, spousal support rules that have flipped decades of legal precedent upside down, and brand new regulations about digital assets that are catching everyone off guard.
Whether you've been married 20 years or you're picking out wedding rings next month, what I'm about to reveal could be the most important legal information you'll hear all year.
Welcome back to the channel. Today, we're diving deep into the most significant changes in marriage and divorce law that have emerged in recent years, with updates that are actively reshaping how couples navigate their legal relationships in 2026. This isn't just theoretical legal jargon. These are real, practical changes that are affecting real couples in courtrooms across America right now.
We're going to break down everything from how courts now handle cryptocurrency and divorces to the new standards for prenuptial agreements, from the evolution of spousal support to how your social media posts can be used against you in court. Let's get started. The first major shift we need to talk about is how divorce courts now handle digital assets, and this is affecting virtually every divorce proceeding in America today. Your cryptocurrency holdings, your NFTs, your online business revenue streams, your content creator accounts, even your frequent flyer miles if they have significant value, all of these are now under intense scrutiny in divorce proceedings. Courts have developed entirely new frameworks for discovering, valuing, and dividing these assets that simply didn't exist a few years ago. Courts now require complete disclosure of all digital wallets, cryptocurrency exchanges, blockchain transactions, and online business accounts. The days of hiding Bitcoin in a digital wallet and hoping your spouse never finds out are over. Forensic accountants who specialize in cryptocurrency tracing are becoming standard practice in divorces involving any significant assets.
The penalties for hiding digital assets have become severe, including potential perjury charges, contempt of court, and judges awarding disproportionate shares of other marital assets to the spouse who was honest. Courts have also gotten sophisticated about valuation methods for volatile digital assets, using snapshot dates to establish values and prevent manipulation during crypto market swings.
Prenuptial agreements have undergone perhaps the most dramatic transformation. Prenups used to be primarily for wealthy families protecting generational wealth, but they've gone mainstream across all economic levels. However, the standards for creating a valid, enforceable prenuptial agreement have become significantly more rigorous. Full financial disclosure is now absolutely non-negotiable.
Courts are throwing out prenuptial agreements at unprecedented rates when they discover incomplete financial disclosures. This isn't just about listing your bank accounts. Courts want comprehensive financial pictures, including expected inheritances, business ownership interests, stock options, retirement accounts, even potential future earnings if they're reasonably predictable. Both parties must have independent legal representation in most states for a prenup to be considered valid. The days of one lawyer drafting an agreement for both parties are gone. Courts want to ensure both spouses understood what they were signing and had advocates protecting their interests. The agreement must also be executed well in advance of the wedding, typically at least 30 days, but many attorneys recommend 90 days or more. Signing a prenup the week before your wedding raises serious red flags about coercion and duress that could invalidate the entire agreement.
The content of modern prenuptial agreements has expanded into territories previous generations never imagined. Today's prenups commonly address social media behavior during marriage, ownership of content created during the relationship, disposition of frozen embryos if the marriage ends, division of cryptocurrency and digital assets acquired during marriage, and even pet custody arrangements.
Speaking of pets, this represents one of the most emotionally charged developments in family law. Courts are finally acknowledging that pets aren't just property to be divided like furniture or vehicles. Progressive jurisdictions are now considering the best interests of the animal when making custody determinations.
Judges examine factors like who primarily fed, walked, and cared for the pet, who paid for veterinary expenses, whose name appears on adoption papers, and the pet's emotional attachment to each spouse. We're seeing actual pet custody agreements with detailed visitation schedules, holiday rotation plans, and shared responsibility for veterinary costs. Spousal support, commonly known as alimony, has experienced some of the most substantial reforms. The traditional model of permanent alimony that could last a lifetime is rapidly disappearing across most states. Lawmakers have implemented durational caps on spousal support that typically correlate with the length of the marriage. A 5-year marriage might result in 2 to 3 years of support, while a 10-year marriage might warrant 5 to 7 years. The underlying philosophy has shifted dramatically. Spousal support is now viewed as rehabilitative rather than permanent, designed to give the lower-earning spouse time to become financially independent through education, training, or career reestablishment. Important exceptions exist for longer marriages, particularly those exceeding 20 years, which may still result in longer-term or permanent support. Cases involving disability, significant health issues, or situations where one spouse sacrificed substantial career opportunities to support the other's career advancement or raise children receive different treatment. Cohabitation clauses have become standard provisions in spousal support orders. If the recipient spouse begins living with a new romantic partner, support can be modified or terminated entirely because courts reason that cohabitation reduces living expenses and financial need. Marital property division has evolved in nuanced but significant ways. While the fundamental distinction between community property states and equitable distribution states remains, how courts classify and value certain assets has changed substantially. Businesses started before marriage but grown during the marriage now undergo sophisticated valuation analyses to determine what portion of growth constitutes marital property subject to division. Retirement accounts and pensions are being divided with greater precision using actuarial calculations that account for future growth potential and survivor benefits. Inheritances and gifts have traditionally been classified as separate property, but the tracing requirements have become extraordinarily demanding. If you inherited money and deposited it into a joint account, then used that account for mortgage payments, vacations, or other marital expenses, you've likely transformed separate property into marital property through commingling. Courts now require meticulous financial records, sometimes spanning decades, to successfully trace and reclaim separate property. Student loan debt has emerged as a major battleground in divorce proceedings. The question of responsibility for educational debt incurred during marriage has produced inconsistent rulings across jurisdictions. Some courts treat it as marital debt, subject to equitable division, particularly when both spouses benefited from the enhanced earning capacity.
Other courts assign the debt entirely to the spouse who incurred it, especially in shorter marriages or when the education didn't produce the anticipated financial benefits.
Technology has revolutionized the divorce process itself in fundamental ways. Virtual mediation and remote court hearings, normalized during the pandemic, have become permanent fixtures of family law practice. Many states now permit entirely virtual divorce proceedings for uncontested cases, dramatically reducing time and expense. Digital evidence has become standard, with text messages, emails, social media posts, dating app activity, and even smart home device records regularly introduced as evidence. That angry text message you fired off at 2 in the morning during an argument could be displayed on a courtroom screen for a judge to analyze. Social media posts showing expensive purchases, lavish vacations, or new relationships can impact spousal support, asset division, and custody determinations.
Divorce timelines have changed significantly across different jurisdictions. Some states have streamlined their processes, allowing uncontested divorces to be finalized in 60 to 90 days. Others have implemented mandatory waiting periods designed to reduce impulsive divorce filings. Mandatory mediation before litigation has become standard in many courts, with judges requiring couples to attempt mediation before scheduling trial dates.
Child custody arrangements have shifted in ways that cascade through the entire divorce process. Strong presumptions favoring shared parenting time have emerged in many states. Courts begin with the assumption that children benefit from substantial time with both parents unless safety concerns exist. This affects spousal support calculations, influences decisions about who keeps the marital home, and impacts relocation requests.
Marriage and divorce law in America is evolving more rapidly than at any point in recent memory, driven by technological advancement, changing social norms, and courts struggling to apply old legal frameworks to modern realities.
If you're currently married, the most important action you can take is having open, honest conversations with your spouse about finances, including all digital assets, and seriously considering whether updating estate plans or creating postnuptial agreements makes sense for your circumstances. If you're planning to get married, take time to have conversations about prenuptial agreements, even if discussing the possibility of divorce feels awkward.
And if you're currently going through a divorce, understand that the legal landscape has transformed dramatically, and you need legal representation that understands current developments. If you found this valuable, hit that like button and subscribe to stay updated on legal changes affecting your life. Drop a comment below about which aspect you'd like me to explore further, and share this with anyone navigating marriage or divorce. Thanks for watching, and remember that understanding your legal rights is one of the most important investments you can make in your future.